Leanne Cusack has a guest with her who is helping families deal with custody and support issues during the COVID crisis. Leanne?
Thanks, Graham. Yes, families are facing many challenges, and that's amplified for families dealing with custody issues. Tanya Davies joins us regularly to discuss family law. This unprecedented time has raised many viewer questions about custody and support. Hi there, Tanya.
Good afternoon, Leanne.
Now, how would the law treat a parent violating a custody arrangement when they're using the risk of COVID-19 exposure as the reason, Tanya?
So ever since this pandemic started, Leanne, the courts are actually releasing a lot of precedents, and clients are bringing emergency motions on this very issue. So if one of the parents is denying access, simply blaming COVID-19, now we have the law that came out and all the precedents that state that COVID-19 in and of itself is not a legitimate reason to deny access. It's not in the best interest of the child to stay away from the access parent. It's not healthy for them emotionally, psychologically. Children, especially during these unprecedented times, need the love and support of both parents. So what the courts are telling us is that what would be a legitimate reason to actually suspend access and do it legally at a motion would be non-compliance with all the safety protocols, safety measures and procedures that Health Canada tells us to comply with during COVID-19. So if you have concrete evidence that the access parent is not complying with these rules, then you can bring an emergency motion, and under those circumstances, most likely access will be suspended.
Well, with the courts essentially closed, what recourse do parents have if, in fact, that happens?
So the courts are not fully operational. There are no proceedings in person, but courts are still hearing emergency motions. We argue them via teleconference. They still run case conferences, which is the first mandatory step of the court process. The same thing, they use the same method via teleconference. They basically give you recommendations at the case conference, and now they're dealing with 2 issues per matter that are pressing issues. And again, of course, if it's an emergency, you can schedule a motion, you can argue it over the phone. We also at our office conduct lawyer-assisted mediations. This is the first resort now, since Chief Justice of Ontario told the lawyers and the parties to be cooperative. It's COVID-19, the courts are already overwhelmed. So we conduct mediation sessions on Zoom and on Skype.
Everything's changed, hasn't it, Tanya?
Unfortunately.
Now, is a parent, and this is a question that I think you've received from many people, is a parent who takes on an increased custody role with the consent of the other parent during the pandemic entitled to more child support?
So the word custody itself refers to decision-making in relation to the child. Decision-making in and of itself would not trigger any changes in child support. The child's living arrangements would. So child support is based on the Child Support Advisory Guidelines. It's based on the payer's income, the number of children. So if one of the parents has primary residence and the other parent has access, then the access parent would pay the whole amount of support pursuant to the guidelines. If the parents are in a shared parenting arrangement, it would be an offset amount compared to the parent with lower income. So the highest income earning parent actually pays the difference of child support. So if that arrangement were to change, then in theory, child support should be pursuant to the child support guidelines as a full amount. But due to COVID-19, we're hoping that parents would be reasonable and they would say if you lost your employment, for example, you could pay less or maybe something in between a set-off and the full amount pursuant to the guidelines.
Tanya, it sounds like you have a lot of those cases potentially on your desk. Last question, and it will have to be a fast answer because we're almost out of time. We have heard the last time you were on, you said that you're already seeing evidence of an increase in divorce rates. What's happening in your office or in your scenario? What are lawyers in family law seeing right now, or is it too soon to tell?
There is no question, Leanne, that as soon as the courts fully reopen, there would be a gigantic influx in the number of divorces. What we're seeing now is actually changes in terms of people's inquiries, in terms of what it is that they're looking for and how they're seeking to get a divorce. So prior to COVID-19, people made a well thought out, gradual decision to proceed with their divorce. Now it's more spontaneous, it's emotionally driven. They're basically telling us, I cannot reside with the other parent in this household anymore. They're pushing my buttons, and they're seeking guidance and advice on proceeding with a separation.
Thanks for the answer, Tanya. Probably not the most cheerful discussion as we head into the Mother's Day weekend, but it is what you are dealing with and what other family lawyers are dealing with. We have a link on our website to Tanya Davies. Thank you very much. Graham.